it on.
Oh, okay.
Well, welcome.
Thank you. Good morning.
We'd like to start off with having you tell us why you'd like to be a circuit court judge.
Okay. I'm Elizabeth Blackburn, or Liz, as many of you know, and I've been practicing here for 25 years and grew up here in Volusia County. I've had a varied background, not just from the legal standpoint, but even before that. I was a teacher before I went back to law school, taught special education, learning disabled children, and then went back to law school and have had the opportunity, the first part of my career, to be a prosecutor. And as I rose in the state attorney's office, had the opportunity to be a division chief for the West Volusia office and supervise a number of folks, lawyers and staff over there, as well as prosecute some significant cases. And then had the opportunity to become the homicide division chief for Volusia County for the last year and a half that I was with the state attorney's office. So all I did were homicides, and worked on investigations and search warrants and the grand jury presentations and capital litigation as well, and have prosecuted two cases that are resulted in convictions where people are sitting on death row still at this point. And when I left the state attorney's office and went into private practice, did a lot of different things, as often people do, trying to kind of open a new chapter and see what fits. Did some criminal defense, which is sort of a natural progression, and then developed a family law practice that really became time-consuming and became the focus of my practice. Became board certified in family law 5 years ago, and throughout my career, and as you can tell from my application, when I first left the state attorney's office, I applied for a judicial position. And I've been a lawyer about 10 years, and I had just left, and other than being a state attorney, I was, at the height of a prosecuting career. As I've continued to practice now 15 years later, I realized how ill-prepared at that point I would have been to be a judge. And I think as you continue not only legal experience and doing a variety of different types of practice, and dealing with clients and running a business and all the things that go with having a private practice, but you gain life experience and you gain perspective. And we are at what I think is a critical point in our judicial situation, where for our circuit this is unheard of, to have this wave of change that we're going through. And I think it's very important to have folks who have a broad base of experience, legal experience, but life experience that they can bring to the bench. The circuit bench in particular, you're dealing with significant issues on a variety of levels, whether they're financial issues or criminal issues with significant crimes, or dealing with families in crisis in a dependency court. You've got a whole host of issues, some of which are complex legal issues, some where you have a lot of in family, which this lot is supposed to be. You're dealing with a lot of folks who are pro se, unrepresented. So I think my very background and the experience that I have would lend itself well to not only deal with the legal issues that are presented in that courtroom, but also from a practical standpoint of dealing with folks from many different walks of life, who outside of whatever issue I would be dealing with them, I wouldn't maybe otherwise come in contact with them. But you learn how to treat folks with respect, regardless of what their situation is. You may not approve of their lifestyle or decision making, but you can make judgments as a judge without being judgmental of the people. And I think it's important I think that's something that I can also bring to the bench. I think it is, to me, being a is something that we as lawyers you want to aspire to. You want to have respect for whoever is sitting on the bench. And you want that person to be respectful of you either as a lawyer coming in front of the judge or as a litigant coming before them.
You mentioned pro se litigants. Can you share with us your view of the role of a judge when dealing with a pro se litigant?
That can be a dicey role sometimes because, you cannot legally advise them. And a judge really has to be that referee person. So you can't give them legal advice. You can certainly, our circuit has that support system in place, so you can sort of point them to the direction of the family law support, but that's limited in nature too. So I think you have to be careful. You can make rulings based on what's before you. You can't help them present their case, although there's certainly, I know dealing with cases where I've been representing one party and the other party's pro se, sometimes there's a tendency to have a little more latitude when the other person's pro se, and I think judges have to be careful of that. The biggest thing I think with dealing with pro se cases is we are seeing such a huge growing trend that's going to become more of the norm, especially in our county's Volusia and Flagler in particular, I think. And I think we've got to be realistic and be prepared for that. And I think you have to really have the right temperament to deal with that as well, because it's very different walking in to a room full of lawyers who, like Mr. Smith and others who practice for years and know exactly what they're doing and know how to handle the situation, than dealing with a courtroom full of regular people trying to get their family through this situation. They don't have the ability to hire a lawyer, and knowing how to deal with that without losing your cool, because you're dealing with the volume that you're dealing with. And I suspect that's only going to increase.
A related question, which would be, what's your view of the role of judge when dealing with an inexperienced attorney?
I look back to the days when I first started, and I had a situation where the judge that I initially practiced in front of, you would know, or you would try not to make eye contact, because if somebody was doing something wrong, it wouldn't be a pretty sight. And I think your role as a judge for young attorneys really is to help mentor to some degree. You can't do their job for them. You can't step in and, if they're prosecuting, you can't take that role on for them, obviously. But I think you can help give feedback that is constructive criticism, and do it in a way that is not embarrassing to somebody. I think attorneys have, as you practice, we've all probably seen situations where perhaps a judge has said something that maybe they wish they had handled differently. You never want to see anybody called out in front of a courtroom and embarrassed in front of their client or that type of thing. I don't think that's appropriate. I think there are ways that you can give people constructive feedback if there needs to be that, in a private manner that's respectful of them, but helps them become a better lawyer, because that's going to help you be a more efficient judge in the long run.
Liz, do you have any ideas as to how to make the case management process more efficient?
Gosh.
Especially for private attorneys.
For private attorneys, I know. As a private attorney, obviously, our pet peeve is spending a lot of time sitting in court, not getting a lot done, and waiting. I think what I see is, if you allow those cases where both parties are represented by attorneys, and allow the attorneys to work the case to a certain degree before you have to get to case management, that sometimes seems to be a more efficient way, because as attorneys we know the first, whatever the time period is for that particular case. When it's a brand new case, you don't have a lot to tell the court because you're still trying to get discovery in a family case. I'm talking about getting the discovery and the initial information that you need. So I think it's a little different from that perspective. You know, I think the goal of the court is obviously, as a judge, you don't want to waste the party's time or money paying attorneys to come to court and you don't get anything done. But you, as the judge, have a role also to make sure the case is moved, and you don't want to have cases that languish. And certainly there are, you know, Supreme Court deadlines that are management deadlines that they try to get the cases moved within a certain time period. I think some of that has to be done on a case-by-case basis. There are lots of cases, I think, that fall in the category of they can go kind of a traditional, you know, maybe after 90 days, we ought to be able to have some idea of where we're headed, that kind of thing. And there are other cases that, because of the issues involved, are very complex and complicated and are going to take longer to get to the point where you're really ready to be before the judge. So.
The first time I joined this body was summer 2012, and I was assigned to vet you and just very impressed with you, and your name went forward to the governor. And so I'm wondering, it's a two-parter, you know, what happened with that process? What did you learn? And then we haven't seen you in a couple of rounds, and so why now?
Okay. The process when you get nominated is a very interesting process and very different from this process. The whole process, frankly, is very humbling. You get people who maybe have known you for a long time, who are, you know, rooting for you and encouraging you, etc. But you also get folks who I may only meet in the process who go above and beyond because they are willing to support me, and it's incredibly humbling. And it was a good experience. You know, I've been honored by being nominated by the commission, your predecessors before, and it's very much an honor to do so. The last time, this most recent slot that came up when Judge Nichols got appointed, who I'm pleased to say is a good friend as well, so it's always nice to see that appointment. My office was in a situation, I was incredibly busy. As you know from my application, I'm very involved with the bar in rules committees and appointed as a vice chair on one and co-chair on another, and had a lot of projects going there. And I also, unfortunately, had my assistant at the time, who'd been with me for probably 20 of my 25 years of practice. She was actually my very first secretary as a lawyer. Got diagnosed totally out of the blue with acute leukemia. And that kind of threw my office in a tizzy for a while, as a private practitioner can perhaps appreciate. And I was kind of regrouping and having some staff issues trying to get situated with that. And it just frankly was not the right time for me to go through that. This is a time-consuming process if you're going to do it well. And I just felt, I knew, you know, my desire to be appointed as a judge hadn't changed, but I knew for me, just because of those circumstances, I needed to wait. So hopefully that answered your question.
Liz, our criminal system hasn't changed in the 40-some odd years I've been involved in it, and I'm sure it hasn't changed any with you. You ever given any thoughts of why nobody or why the judges have not changed any of the procedures of the way things are occurring over 40-some odd years? Why can't somebody be innovative and thought maybe some things that can be done to change the situation, make it more effective?
You're right. I think it is largely the same. I mean, my husband practices a lot of criminal law. We have a lot of discussions about that, obviously, and I don't have anything specific that comes to mind that would be an overhaul of the system. You know, I think I would suspect that we're going to see some changes because we're going to see changes in personalities on the bench locally, frankly. You know, and one of the things professionally to me that's been incredibly gratifying, I just got appointed by the president of the bar this year to head the Family Law Rules Committee. We're doing a huge project related to all the rules of procedure and that govern family and combined with civil. And I think that level of involvement will help to have folks who are really involved and committed to the profession of law to kind of move it forward. And I'm not sure that answers your question very well, but I think certainly there's always room for change, and doing just because we've always done things that way doesn't mean it's a good way necessarily. And I would hope to, you know, if I were to be appointed, I would hope to bring my desire to have a really high level of professionalism here, and, you know, create some discussions about what can we do differently as we move forward. Because we're going to have a whole new cast of characters, as you would, or, you know, we're just having such drastic changes on the bench, and I think that gives us that opportunity to do that.
And so you would be open to input from the bar on those issues?
Oh, I think you have to be. I mean, you know, you as a practitioner, you want to be able to have communication with whoever the judge is that you're appearing in front of, so there's some of that communication. Look, hey, I heard this is what they're doing someplace else. I think this is a great idea. You know, I think that's important.
Well, thank you for coming in this morning.
You're welcome.
Thank you for your time. We'll be letting everyone know about the list by the end of the day tomorrow.
Okay, thank you very much.
Nice to see you. Thank you, Ms. Wagner.